Sarah Palin and her legal team were pretty much laughed out of court this week after they tried to tell the very judge who oversaw their first trial that he didn't do a good enough job and he needed to order a retrial. And of course, the judge wasn't having any of it because, it's never a good idea to go to the judge that oversaw your first failed trial and tell him, "Judge, we don't like you. You didn't do a good job. There's partisans in the jury, which you didn't weed out. So we want a new trial." Judge said, "Yeah, absolutely not." And in case you're wondering, the trial, of course, was the recent one that took place where Sarah Palin had sued the New York Times for libel, basically saying that an article they ran blamed her for a shooting that took place because she put out an article, not an article, but an ad that had crosshairs on members of Congress. Then, of course, one of them got shot. They blamed her for it, which, of course, you can't really do that because you cannot prove that she did it. So she sued them for libel. But before she sued them, obviously, the New York Times had issued a correction, said, "Hey, we're very sorry for doing this. We shouldn't have. We were wrong." That actually happened shortly after they wrote the article because, they screwed up big time. But during her trial, the judge says that Sarah Palin, her legal team, couldn't provide, quote, even a speck of evidence to show that the New York Times acted with actual malice, which, of course, you have to have if you want to prove a libel or slander case. The judge said, quote, "And the striking thing about the trial here was that Palin, for all her earlier assertions, could not, in the end, introduce even a speck of such evidence." So the judge, in issuing that statement this week, basically said, sure, you're claiming the jury was rigged. You're claiming that I was, not up to snuff here. But the real issue, the reason you lost was because you had no evidence to back up your claims. Now, I had said in the past, Palin had a pretty strong case, right? And I still think she did. But the jury disagreed. And I was not a part of the trial, so I didn't get to see, of course, the fact that Palin apparently didn't introduce any evidence to back up her claims that the New York Times did this with actual malice. And then, of course, we have the other part of it, which is she suffered no damages. That's part of the problem that a lot of people overlook, by the way, with slander, libel, and defamation cases. One of the things you have to be able to show is that the slander, libel, or defamation cost you your job, cost you future jobs, opportunities, advancements, or cost you financially. Sarah Palin suffered none of those from this New York Times article. Right? You didn't lose jobs because of it. You're not unemployable today because of it. You lost nothing. You had no actual damages, which of course is why the actual malice comes into play. They had to knowingly and intentionally write something that was false for the purpose of hurting you. And you couldn't prove that they actually did it that way. Basically, let me put it this way. Suppose the New York Times comes out, runs an article that says that, Farron Cousins only has 8 toes. I don't immediately get to sue them for libel. I have 10 toes, in case anybody wondered. Because even though it's a lie, one, I would have to prove that they knew it was a lie before they published it. And two, I would have to be able to show that them writing an article saying I have only 8 toes has somehow cost me, future gigs, or that it hurt the fair and balanced brand. It wouldn't do that. So I wouldn't actually have a case against them. Because in these instances, of course, the law benefits the media outlets. They're allowed, to a degree, to publish things that are wrong as long as, of course, they issue corrections and they didn't do it intentionally. That's actually a Supreme Court ruling in favor of the New York Times many, many decades ago. So Palin failed. She failed because she couldn't produce any evidence. They tried to go back to the same judge and say, "Hey, you're full of crap. Redo this." And the judge correctly told them no, because the problem with your case was that you simply didn't have one to begin with. Hey everyone, this is Aspen. And did you know that for the low cost of $0 per day, you can subscribe to the Fair and Balanced YouTube channel? We also encourage you to like, comment, and share, but again, click that subscribe button and help Aspen not be so grumpy.